Visible? All okay that side?
Yeah. So, good evening to all our respected participants, faculty members, and guests. On behalf of Law Teachers India and SNDP Law College, Pimpri, Pune, I, Vikas Parashar, warmly welcome you to day 2 of our faculty development program on jurisprudence and legal theory. Today, we have with us an academician whose journey reflects both scholarly excellence and passion for teaching, Dr. Preeti Singh. Dr. Preeti Singh is currently serving as an assistant professor at the Faculty of Law, University of Delhi. She holds a doctorate in law from Dr. Manohar Lohiya, National Law University, Lucknow, an LL.M in business law from NLIU, Bhopal, and she is also a law graduate from Manohar Lohiya, National Law University, Lucknow. She has qualified the UGC-NET and is the recipient of the prestigious ICSSR and UGC Doctoral Fellowships, recognizing her contribution to research and scholarship. Dr. Singh has presented her work at national and international conferences, including those held in Sri Lanka and the Philippines. Alongside her academic work, she has actively contributed to legal education and skills development, serving as a judge for moot courts and client counseling competitions at both national and international levels. Her rich academic background and commitment to advancing legal scholarship makes her an excellent resource person for this FDP. So please join me in welcoming Dr. Preeti Singh. Welcome, ma'am. Over to you.
Opportunity to connect with minds. Am I audible?
Yes, ma'am. You.
Any issue?
थोड़ा डिस्टर्बेंस आ रहा था आई थिंक
There was some voice.
Still some issue?
It's better now, ma'am.
I think I should switch off the fan. I think that's making some noise. If it is.
I don't think so.
अभी ठीक है अभी
Ma'am, it's perfectly audible.
All right, all right. So I was just saying that I'm very thankful to Vikas and Dr. Kalpesh for considering me here and giving me this opportunity. So as I'm briefed that I have the audience, the mixed audience comprising of the UG, PG, faculties, advocates, and many other people belonging to the legal fraternity. So as we have a time of 1 hour, and first of all, I'm very sorry to all the candidates for making you sit at 8 o'clock in the time of the evening. But because of this, I wanted that I should be free and able to discuss with you all. So for me, today's, as we have a lecture on classics of jurisprudence, I also prepared a short PPT for you, but I don't want that this should be some like one-sided approach. I believe that the participants should also be interested and will be making some discourse on that, so that it's not a lecture-based something on the class or the other thing. It should be something, an interactive session whereby we like discuss, debate, discuss, and come up with something new on that. So let me share my PPT with you for the consideration. Just a second. Is it visible?
yes yes visible
Perfect.
yes.
All right. So today, as we have this lecture on classics of jurisprudence, so I thought to make it like we have number of things to discuss on this topic. And I tried to streamline particularly to natural law school and the positivism and try to understand what classical jurisprudence understand in that sense. I was very like felt amazed seeing the topic classical jurisprudence, because we have always discussed jurisprudence divided into various schools like positivist school, positivism. Then we have divided into other school, historical, sociological. But calling it as a classical jurisprudence again raises the question, why classical jurisprudence? What is the need of studying the classical jurisprudence? So if I have anyone before starting of the lecture that anyone has any understanding with respect to classical jurisprudence, I'll welcome the comments from the participants if there are any, else I am there to discuss the same. Are you able to see my screen? That is okay. All right, not an issue. So proceeding further, I have streamlined certain objectives for our discussion today. That first of all, we'll understand why classical text and jurisprudence are important, because discussing on anything makes it very important why we are studying this thing, what is the rationale behind it. Then we'll select some of the key contributions of the classical jurist, because we cannot cover all of them at one go. Then we'll try to critically evaluate this relation, how they are still relevant today, like thousands of years ago, they were being given, and still why they are relevant in the modern legal theory. Then we'll distinguish between different schools of thoughts in classical jurisprudence. So this is the flow of our discussion today. That first of all, I will discuss with you the importance of these classical texts. We'll be primarily focusing today on natural law theorist and the legal positivist. If time permits today or in future, we'll move up to the other theorist also. And then we'll do a comparative analysis and we'll understand what makes us to still study these things. So first of all, my question as I started from the very beginning, what is the rationale? Why we are still studying these classical, or why we are still saying it's a classical jurisprudence? What makes us to again revisit these thinkers? Is it just a part of the theory, or is it actually some practice that is going to help us for developing the modern legal theory, developing the jurisprudence, right? So classical as a word, you all understand that be it any stream, be it any sector, when we say anything as a classical, it has a very deep important for us in the study of that thing. So for example, like till now, I think the people, we are all of the legal fraternity. So what we have understood is, we have understood what of the law. So what of the law, and the next phrase is why of the law. So today we'll be more discussing on this why of the law, not on what of the law. So am I audible? Any response, Kalpesh, sir? Am I audible?
Yes, ma'am, you're audible. Perfectly
Okay,
audible.
okay, all
Yes,
right,
yes.
perfect. No issue, no issue. So this is what we are now discussing today. So for when we see classical, for example, you have read a law, just to take an example, the Constitution of India, right? Being a law student, being a law teacher, we understand Constitution of India as a legal document and everything that is there in the Constitution. But now it becomes very important why it is there in the Constitution. So if you have not gone through the Constitutional Assembly debates, it's very difficult to understand what was the rationale behind that thing. So similarly, it is with the jurisprudence. Now, we all understand that why we divided different schools of thoughts in the jurisprudence. So to my understanding, if I say, like in a society, we in India never have a one approach to anything. We still follow, like, there are many perspectives of a thing, and being in a democratic country, we have majority and the minority. So similarly, when it comes to the jurisprudence and talking about the rationale of the topics, why we are discussing classics on jurisprudence. So this is what makes you understand that what was the importance of these philosophies. I'll not say only a jurist, because they were not the lawyers or the person who have studied the law at the very beginning and then only came up with the law theories. There were many people who were the politicians, who were theologians, who were not actually into the realm of law, still given various theories which affected law in general. Because law is something which is a part of our society. We say sometimes, or many times, law is a branch of social science. Now, in a society, whatever we study as the law is, again, we are understanding the society, because that is there in the society. But until and unless we are not exposed to law, we are not being the law student, we are not being the law teachers, it becomes difficult that we understand that thing from that perspective. For example, for us, whenever we were before class 12th or before our law graduation, what was Constitution for us? Constitution we never seen is with this perspective as we are not seeing in the law. It was just a book, or even some of us were not knowing how it looks like. We have just studied in the political science or the politics. But now when we talk about jurisprudence, this is all like jurisprudence, juris plus prudence, that is knowledge of law. We keep coming with this phrase, knowledge of law. Now, where this knowledge of law has finally came now, we talk about the recent school, with that is the American realism, nowadays more applauded with, that it is more realist school of thought. But this thing that we have today must have a foundation or the long journey that was there behind the coming up of this concept. That is why I say that we study rules, we study legislation, we study the statutes, cases. But now the question comes, why? So what we already understood, I'm not going to tell which provision, which section, I'll be only discussing why this thing. So when we say in the Constitution, it means why we follow the Constitution. That is the thing that we need to understand, and that is the part of jurisprudence. Then what is in the Constitution is a part of constitutional law. So these classics, we should understand that these are not the just books. These are not just some theories just given. These form the intellectual DNA of our legal system. That how we came to this intellect, how we finally decided that this is the thing, this is the reason, this is the law, this is the morality. I'm not like criticizing any particular jurist. I'm not supporting any particular jurist, but I'm saying that each and every theory given by the jurist forms a very foundational notion of our classical jurisprudence. So coming to this, there are few examples of classics of jurisprudence. Like starting from the natural law school, if we talk about, we have Plato's Republic. So these are the books, or these are the the written work they have finally produced, and that carry the notions of their understanding of law, society, principle, morality, and this is their work. Then we have Aristotle's also, we have as Thomas Aquinas, we have Hobbes' Leviathan, that is again a very interesting to read about also. Then coming to the positivism side, we have Bentham's Principles of Morals and Legislation. We also have Bentham's Limits of Jurisprudence defined. Austin's, the greatest thing that we see in the positivism is that the province of jurisprudence determined. We also have Kelson's Pure Theory of Law. We also have H.L.A. Hart Concept of Law. So these are few examples of classics. These are with respect to the law point that we are studying jurisprudence. Nowadays, like we all know that Indian knowledge system is again getting so much of importance, becoming you can say a subject in the study, and we have a lot of conferences and seminars being organized on that. So why again we are going or tracing back the thousands of years ago things that are there in that? Because still we always want that if something is there, there must be some roots, there must be some foundational thing. So in jurisprudence also, if we try to study historical, if we try to study sociological or even the American realism, we need to know that what was the basis of that. Why this reaction or why this school has came as a thought. Because in India, if you talk about, let's say one example, like the example of a third gender. So we are living after the Nalsa judgment, we can very well say that this gender or third gender is recognized. But before that, was it a law or just a part of the morality? Was it only in India or in any other states? So the point is that with respect to the time, with respect to the progression, because we do not want India to be just a static, not just to be a developing, we are always progressive towards a developed society. So we want to be a progressive society. Hence, it might be the reason that we valued customs. It might be the reason now we are analyzing those customs with the test of the realm of the law, whether they can be validated nowadays. Then finally, we may be like following American realism. Yes, this is the need of the hour, and hence the courts are coming up with the like guidelines for that, and then the legislature also legislating on that. So this is the whole process. It is not the law that we have in hand one day is the result of just passing of the law. There are a lot of things that are involved behind that. So classical jurisprudence makes us understand the foundational of the jurisprudence, right? On what all foundations we have developed this jurisprudence, various schools, various theories, and still it is, we are just exploring the same. Many people are getting the patents, like they developed a new school of thought. Because for example, I'm an individual. Today I decide that no, I am not convinced with any of the philosophers or any of the school's thought. I developed my school of thought, and I have a rationale behind that. That can be my like my view, my understanding. I may then have my 5 other friends who also agree with me. Then that becomes a particular school of thought for that understanding. So this is the broader categories, like natural law. If we say everyone in like being the humans, we all understand what is natural law, but how to pen down that thing. So these were the people at that time who have finally understood and recognized and finally penned down or written down those things. And similarly, you will see in the positivism, we also believe that law given by the written as it is the law. Point is, who has finally come up with that in the thing. So when you see Bentham and Austin, we say Bentham has talked about these things very before Austin has talked it. But the point is, Austin has finally legitimized and get it published. So Austin was recognized. So that is the procedural aspect of the things. Now, our focus today will be that we'll quest or we'll understand the natural law, that how the quest for a higher moral foundation of law with special focus on the Thomas Aquinas. We also have other jurists, other theorists in that, like Plato, Aristotle, Socrates, but today we'll focus more on Thomas Aquinas. Then we have legal positivism that talks about the separation of law and morality, what the law as it is and what the law ought to be, and which law is for us the law as it is. Then we'll focus on Bentham and Austin particularly. Then we'll see that in the present scenario, how this hierarchical model is existing, then the pure theory of the law. And then we'll also see the concept of law, which is given by H.L.A. Hart, how he has finally came up with new theory or the new perspective, seeking Austin, the natural law jurist, and the pure theory of law, and coming to the modern law concept, right? So next, we have natural law theorists, and we all know that when we talk about the natural law, it's more divided into ancient period, medieval period. Then we have the dark age, also the period of the Renaissance. Then we are coming to the modern time, right? So like little focus of that is also required to be understood before moving further. So when we talk about natural law jurisprudence, so the classical we have is like the Plato, the Aristotle, right? Then before that also the Socrates. And one thing, what we need to keep it in the mind is the background of these thinkers, these philosophers. When you see Socrates, he was a teacher of Plato, or you can say Plato was a disciple. Then Plato, again, the teacher of Aristotle. Then further Aristotle, the teacher of the Alexander the Great. Then we should understand that the upbringing of the a person and the atmosphere under which the person is building up, that plays a lot of role. So for example, today I am of the perspective that I am very realistic. So the new generation, somebody raised the hand.
No problem. Please carry on. I think
Okay.
by mistake.
Okay.
Yeah,
Okay.
thanks.
All right, just a second. Okay, so I was talking about Plato, Aristotle, Socrates. So when we talk about like these thinkers, it is the legacy that they have carried upon, and that has affected their thinking process also. And that's why they belong to the one school of thought. For example, many of us like must have done the PhD. So we have seen, if our supervisor is so liberal and so supportive, the same legacy we carry on. We also are very supportive and liberal towards our own scholars. But for example, our supervisor was very strict, very adamant. We also somehow, even knowingly or unknowingly, that instinct is built in us. And that is also one of the good example is of ragging also that you can see. So similarly also with the thought process of the jurisprudence, when we talk about, we see that if there is some disciple or somebody, it might be the reason that disciple do not agree, or disciple gives a new theory. There are many jurists, many theories that we will talk about. But the point is, either he will criticize his the person who was there, or he will support. In both ways, the foundation thing that was laid down by that person affects his thinking, affects his rationale, and coming up of his theory. So when we talk about Socrates, so for Socrates, again belonging to the natural law school, again thinking that there is something that is above the positive law, that is emanating from the God, and that's why the natural law. So Socrates thinks that it's the human insight that helps us to decide between what is good and bad. Means as a human mind, we always understand what is good and bad, and it's our insight which finally lets us know what is right, what is wrong. So we as a humans do not blindly follow whatever is the law. It is us, the insight of us, that helps to decide actually what is right and what is wrong. Now, building upon this concept of Socrates, Plato was of the view that yes, there should be yes, there should be regulations. There may be the philosopher king regulating all these things at this superior level. Then there's the guardian class of the people who are regulating the other class of the people. And then he divided it more into spiritual world and the physical world. Now, the idea behind the spiritual world was that it is perfect. For example, if we take an example of pizza, we have one pizza, we have ordered the farmer's pizza, and that is with some customization and specifications. But we know this is the one thing, अब इससे अच्छा कुछ नहीं होगा, इससे बुरा कुछ नहीं होगा, ये perfect है. So we say perfection. So we talk about perfection in the spiritual world, and in the words of the Plato, then we say that what is in the physical words is the shadow of the spiritual world. It might sound something different, but yes, these are the theories, how they have interpreted the things in the age of the natural law. So we think in spiritual world, there is no problem. We presuppose that it is a perfection. So I think every theory is based on some presupposition, and we all, being the law students or the law researchers, understand that whenever we start some research also, whenever we start delving into any of the topic, we have certain presupposition. For example, when you join this course, you have certain presupposition that what all could be a part of it. When I like preparing this thing for you, I have certain presupposition that how I will deliver, what I will deliver, right? So this is about the Plato's theory. Then influenced by the Plato, Aristotle also, like again the teacher-disciple thing, Aristotle also comes with this idea of justice and principle and morality. So he thinks that yes, the God has created the things, but yes, it is the reason that is in the human being that helps us to understand. In any way, our positive law or any law developed by the humans or the man-made law should not be in derogation of what is there in the natural law. Then this is about the ancient time. Then in the medieval time, if you see, we have Saint Thomas Aquinas. Now, before that, many of the students who belong to the political science must have understood. I'm not that political science student, so I may not be able to delve more into that concept of like how the church was supreme, how the supremacy of the church was being challenged or again re-established, or the period of the Renaissance. So after that age, so what Thomas Aquinas, from his name only we can understand, it's a Saint Thomas Aquinas. So he somehow wanted to synthesize Christian theology with the philosophy of Aristotle, means somehow again re-establishing the importance of the church. So he somehow we can say he has again streamlined the laws into different categories. So the 4-tier system or the hierarchy of the laws he has came about. But yes, there was no proper linkages into that laws as Kelsen in the positivism have came about. That is the grand norm, that is the basic norm, other norms will derive their validity. So that you will not exactly found what the Saint Thomas Aquinas. But again, this gives a foundational aspect of understanding for the other thinkers of that period. So he categorized laws into 4 things: eternal laws, natural law, human law, divine law. Now, what he means to understand, I'll not say what we means to understand. So first of all, he thinks that whatever we say that the laws that are emanating from the God, or the God means laws or the will of the God, that is eternal law. So he says that God's plan for the universe. So there are certain laws which are there, and it is unknowable its entirety to humans. So we as a humans don't know actually what are all eternal laws. It is the God's will, right? And we being the humans maybe just like understanding few things of it. But yes, what is the total plan? It's up to the eternal law. Then he talks about natural law. Natural law is something which we discover by the reason. Means, yes, there is something, we apply our rational, we apply our instincts and come up with something like we understand that thing. For example, the participation of rational creatures in the eternal law. Rational creatures, again, the human beings. So it is discovered by human reason, and it is something which is universal and immutable. So even when we talk about the natural laws, we say that they are immutable. So they are there. The truth is this only. So its first precept is good is to be done and pursued, and evil is to be avoided. So even we by the rational, if we think that this is the discovered by reason to be good, we can follow that practice. But if it is bad, we can avoid that. Now, again, coming to the new thing, the human laws. Human laws, again, we all understand it is something that is man-made. That is like legislations we are coming in. But the point is that they should align with the natural law. Because again, if there is a conflict, then that will not be syncing with the philosophy of the natural school. So these are also very specific. These are not generalized as eternal laws, which is given by the God. So these are the man-made laws which derive their validity, or you can say they try to align with the natural law. So these, like the statutes, like the legislations that we have, so something which is exactly made by these human beings only, not by just the reason, because then again, if you discover it, then that is not your man-made law. So discovery is one thing, making is one thing, right? Then the last is the divine law. So divine law, again, he emphasized, he tried to take a midway, means he again wanted to say that the law emanates from the God. There are natural laws. Then again, he wanted to emphasize on the importance of the judge. Or in that, he said that divine laws which are revealed in the scriptures. Now, the point is, who will reveal what is in the scripture? Then again, the authority was given to the church, that whatever is interpreted, that will be understood as the divine law. So anything that the law that revealed through the scriptures, for example, the Bible, to guide humans to their ultimate end, that is a salvation, that is a part of divine law. Then again, this is the critique, or this is the back end that we can understand by that thing. So again, his point was to find a midway, how to synthesize Christian theology again with the philosophy of the natural law, right? So any law which is contrary to reason, contrary to divine, are invalid. Means either it has to be a God's law, God's will, either it has to be the human reasons that discovered that will, or it is something that aligns with the natural law, man-made law, or it is something which is there in the scriptures and it is like interpreted. And finally, what is the law? That is the divine law. Now, coming to the like final, we can say the classical positivist. Before starting with the Jeremy Bentham, I'll be like talking with you the concept of social contract theory. So we understand that social contract theory is the result of the discussion or deliberation of Hobbes, Locke, Rousseau, and that is the very famous that we keep on discussing. So what happens when we say Hobbes, Locke, Rousseau? So Hobbes, Locke, Rousseau are the thinkers, or you can say classical thinkers that talked about the concept of social contract. Now, why social contract is important? Because when we are talking about natural law, तो अभी तक ये है मतलब God से आ रही है, we are following, either we are discovering from our reasons, but there is again no similarity, no like there is again an ambiguity. Because again, the people who doubt on the God itself, how they can believe that it is emanating from the God. So again, there is no consensus among all that yes, this is the law. Now that belongs to the one segment of the people. So in modern ways, if we see, we find that Thomas Hobbes has said that we are living in a state of nature where everyone fears, or we were living in a state of nature where everyone was in the fear that whether my rights will be suppressed by the other. So the state of nature at the time of the Hobbes, when he developed the theory, he was thinking that everyone, it was like a war of all against all. Like if I'll not protect my thing, either somebody will take it. For example, if in a jungle, like a deer is just standing and not just slept for the few minutes, there is always a fear that the lion will come and eat that. So again, it is a fear among the mind of the people at what he believed, that we are always under a fear that who will protect our rights, how our rights will be protected. So the state of nature was very like a war where everybody is against all, everybody is fighting against all, and there is no unanimity among anyone. So he says that makes people to realize that they should give some authority to someone. Either there should be someone who can look up to their rights, who can fight for their rights. And that is why the Hobbes in his work also, Leviathan, has compared the state as a concept of Leviathan. So Leviathan is like a sea monster, means that like nobody is like can deal with this person. He's very powerful. So he compared that the state is very powerful, and when you surrender all your rights to that state or compared as that sovereign, he will protect all your rights. Now he was talking about the natural rights that time, not talking about any other right, constitutional right or human rights or any other right. So all that was there was the natural rights that was there. So he said that law that will be there, now that will come from the sovereign, that whosoever will surrender our rights, that the person, that the Leviathan will look after our rights and will protect us. So he somehow stated on this concept that state of nature at that time was very chaotic. So that is why the social contract was required, right? That there should be some law and order, how to legitimate the actions. For example, if I am just sitting, somebody is coming and beating me, how to finally find a way, who is right, who is wrong. So it is like people at that time were like, you don't do wrong to me, I'll not do wrong to you. So he supposes that thing, and hence he said that there's a strong state that is needed to avoid anarchy, right? So this is the concept of the Hobbes, and many a times it's been Leviathan, we just understand. But when we talk about Locke, so Locke was not so pessimist like Hobbes. He was very optimistic. He says that yes, I do understand that Locke do understand that there was no law that was there to regulate the people, but yes, the people by mutual thinking, mutual talking, they have decided that I'll protect this, you'll protect my thing, or I will not do harm to you, you will not do harm to me. So he said that even if we say that the state is absolute, then it will again be something that the state is arbitrary. So the point is that whatever rights we are surrendering, that should be voluntarily, not something forced, that all our natural rights should be surrendered. So again, he has given importance to right to life and right to property, right? Just a second. So he wanted to, Locke wanted to align the laws into certain aspects so that can be like our rights are protected and are not being infringed by the others. Then finally, Rousseau was there. Now, Rousseau has given a more refined version of this. Now, if I just quote him, what he said is, man by nature never thinks, he who thinks is corrupt creature. Means he somehow wanted to say that it is the nature of the human being as the rational that they never thinks, but if he who thinks is the corrupt creature. Now, in that way, so the people who were understanding at the time, and from the Rousseau only the concept of general will has came, and we have came to a social contract theory that our rights will be protected. Now, this Rousseau says that at that time, even if the people who are powerful, they might become strong and they might become rich, and the people who are weak, they are poor. So again, it will lead to inequality in the society. So again, we want some sovereign, right? Sovereign to regulate, and that's where the concept of general will came from, that concept. Now, just influence from all these things, a new approach of jurisprudence. So this was natural law, means these theorists, these jurists were more focusing on the law that is eternal, that is coming from the God, that is the God's will. In some of the other sense, it might be that they are parallel, they are not actually equivalent to each other, but they are running on the same track. Then there's a new approach to that jurisprudence, new approach to the understanding of law, and that came from the legal positivism, or we can say the positivist school of law. Now, we have two great proponents for that, Jeremy Bentham and the Austin. Some people always have this debate that why not Jeremy Bentham is the father of the analytical jurisprudence, why only Austin? Why Austin, not only Austin? But the point is, again, we say that we, being the positivists, they follow the black letter law. They follow the written law. So it was Austin whose lectures were finally more like published before this Bentham's theory and other things were recognized as such. So Jeremy Bentham was, you can say, the Austin was the disciple of Jeremy Bentham. And if you see their backgrounds, they were more, if you look also to the Austin's background, so it was more influenced by the army background, or you can say more strict, more rules, more discipline. So Jeremy Bentham, if we just talk about, has talked that yes, this natural law is not a law for the Jeremy Bentham because it's very ambiguous, and he says it's very misleading also. There is no clarity what is law. If you say eternal law, then you say divine law, then you say natural law, then you say man-made law. Then there is an ambiguity. How to understand? Then he says that so for him, there is he do not believe in the concept of natural law as such, right? So for him also, there is no social contract as such. Then what he wanted to make us understand, that law is something which should be as it is. Means this positivist school was more focused on law as it is rather than what law as ought to be, right? So we have two notions like a priori and a posteriori. Again, then he also given the concept of utilitarianism, that like many of us have gone through the case of Spelunction Explorer, have also witnessed that train and the track and the coming and the people working on the track. So how to decide that what should be the law? So he says the aim of the law should be the greatest happiness of the greatest number. Again, we can say it is again the majority we are talking about. And again, that gives the concept of democracy that we are witnessing in the modern time. So he says that this natural law concept is all should be rejected, and the concept or of the codification should be there, so that there is a clarity, there is utility, and there is no ambiguity as such, right? So it is not that we have to come to go to the scriptures and find and interpret. Then again, that interpretation differs from person to person. So to ensure the clarity, to ensure the utility of the law, he emphasized on the codification. And emphasis on the codification is not only because of the Bentham, it is the basis of the the positivist school of law. Then like this is again a very like a stated statement of John Austin. So what he says, that law is the command of the sovereign backed by sanction. So being in the legal fraternity, we are just used to this statement that Austin, law is the command of the sovereign backed by sanction. Now it looks very simple, but to understand it, it is again raising various doubts, various critiques of even Austin are there. So even when Austin talks about law, he says it at the command. So that command again coming from the sovereign, and if you do not obey, there are sanctions. Now, what could be the sanction? Again, it is not defined by the Austin. Ki sanction kya honge? Because in the present time, we understand sanction is a number of things, whether it is in the form of the punishment, whether it is a form of the fine, whether it is some other thing, because now sanction can be something for like a restorative justice. We talk about that we have to rehabilitate a person. Is it a sanction? So again, where the theory of Austin again is not something that we can totally rely upon in the modern time. But yes, that gives us the foundation for the codification of the law. So he says command. So the command theory as per Austin, that whatever is the law, that should be the command of the sovereign. And who is the sovereign? Sovereign should be politically superior and should command it for the politically inferior, right? And then if it is not obeyed, and the sovereign requires the habit of habitual obedience from the politically inferior, and if it is not, then there are sanctions. So it is the duty of the politically inferior to obey the politically superior and the command given by them, and if it is not, there will be sanction. So he tried to separate law as it is and law as ought to be. Now, law as it is something which is black letter law, which is written law. We are talking about, for example, today we say that murder is an offense. We all understand that. Tomorrow somebody comes that murder will not be considered as an offense. Let's just suppose. So can we think as per natural law? We will always think that murder is something that is wrong. You cannot kill any other individual. They also have the right to life. So for any person who belongs to the natural law, murder will always be an offense. But for Austinian sense, for the people who belong to this particular theory, they may agree that murder is murder if it is written. Murder is not an offense if it is not written. So what they want is something that anything that you want to recognize, that should be something that is in the black letter law. If you want that morality to come as a law, please come it with the black letter law. So he want जो जैसा है वैसा मतलब लिखित में होना चाहिए, law as it is होनी चाहिए. हम उसको सोच नहीं सकते कि ऐसी भी हो सकती है या ऐसी थी. Whatever we are, we want as it is. So law as it is that exists is the law for the Austin. So because of it, he was like more influential in establishing the legal positivism in England. Then again, he talked about separation of law and morals, that what is law should be separated from what is morality. If morality wants to become law, it has to be pass from the realm of morality to the realm of law and to be recognized as a law. So now it comes that for Austin, whether law is good or bad, just or unjust, is not a question. It is irrelevant whether it is. What matter is whether it is the law or not. And for law to be law, it should be as codified as recognized, and that is the positive law. And that's why he considered it as a science of law, not as ought to be, because science does not believe on the presumptions. It has a proper experiential thing, and that is the a posteriori notion, that it should be a science of law that can be experimented, that can be understood, right? And that is the positive law. So when we talk about Austin's theory, the province of jurisprudence determined as a classical theory of that, we have the key components: a sovereign, a command, a sanction, and a duty. So sovereign will always be a person who is superior, and that superiority is not any other but politically superior person or a body. It is not only one individual can be sovereign, a body can be also a sovereign, who receives habitual obedience from the bulk of the society that is politically inferior. So sovereign is in a habit of owing that habitual obedience from the other. Now, command is something, an expression of desire that another shall do or forbear from doing something. So this command is emanating from sovereign to the persons who are politically inferior. And politically inferior persons, they are being commanded, they are under a duty to obey. And if they do not obey, then there is some harm. Now, what type of harm? Again, it is very ambiguous, not given in his theory, what type of exact sanction he is trying to talk about. So that is harm or the pain that will be likely to incur if the command is disobeyed. So the critics of the Austin's theory also says that what is this sanctions? Sanctions again are not clear, right? So his theory is being criticized for being too simplistic. Now, what are the struggles of the Austin's theory? So these struggles again highlight the critics of the Austin theory, and these are taken by the new proponents of that school. So again, the concept of customary law. Then the question is, who commands that? Because when we say something as a custom, it has existence from the time immemorial, then where is the sovereign in that sense, and who is commanding it? Concept of constitutional law. For example, we are in India. We have a constitution that is given by we the people of India. And constitution gives the supremacy to the parliament to come up with the legislature to come up with the law. Now, whether the legislators are supreme, whether the people are supreme, or whether the constitution is supreme, who will be the sovereign in that sense? Because sovereign means that his power is uncurtailed, it's limitless, right? So sovereign, if we consider constitution, then constitution is again given by we the people. So who is sovereign? Then if we consider parliament, then if we are considering parliament, the powers are provided by the constitution. Then how the parliament will be sovereign? So again, there is this debate that actually who is sovereign and who is supreme with respect to the theory of the Austin. Now, for example, the law relating to the granting the powers, for example, wills, contract, they are not the commands that are backed by threats or sanction. That is the mutual negotiation among the people. So again, the concept of sovereignty is in question in that thing. Then again, the continuity of the laws. This is very interesting point of the Austin theory. He says that law is something which is a command, and that's why it persists in the society. Now, let's suppose a situation, a sovereign dies or sovereign does not exist. If we say it's a body or a group of persons, now who will command them, right? So the new sovereign hasn't commanded them yet. It might be the new sovereign retract back if he do not follow that thing as the law. So the Austin positivism might follow, like we should follow, it's not might, we should follow as the foundation stone for hierarchical, or you can say making the laws codified, right? So this relevance is there for the Austin's theory for codification of laws or hierarchy of laws. But still, we always understand, even if we talked about the like Ramayana, Mahabharata, or the other Bible or Quran, we always say that for in every religion, we always find some good, some bad practices, right? So our view should be that we should take the best thing and we should avoid the bad thing. And that should be the like understanding for developing nations. Because if we track back, this is bad in any religion, in any jurist definition, will not be able to praise the good thing of that. So we as an individual in the present day time, as we all know, jurisprudence is not the subject of law. It is the knowledge of the law. So we should have the knowledge from different perspective. It is on us to decide that which perspective will be fitted in what situation. Again, there is no straitjacket formula that the Austin's theory is, or this classical jurisprudence is applicable, will provide help in solving these matters or these things. So it is on us, like coming to a like more refined form of positivism. So Hans Kelsen, he has given the pure theory of law. Now he tried to create a pure theory of law which is free from external influences like other disciplines, sociology, politicals, morality. Now, again, presuming this in the real sense is very difficult. We cannot always say that law is something which is again devoid of morality. So whether morality came first in the society or the law came first in the society is again a very debatable thing. Like every individual has his or her thoughts on that. So he taught that law is something which is a system of norms, right? He says that these norms are the ought statements, and validity of any legal norm should be derived from the superior norm. For example, if today we have the Indian Contract Act for example, Indian Contract Act gives like how that Indian Contract Act is legitimized, because that is again before the coming up of the constitution. Then we can see its authority that we have a right to do trade, commerce, business under the constitution, and under the constitution itself we have given the validity to the pre-constitutional laws, and hence today the Indian Contract Act is still valid. So as per Kelsen's, he replaces the sovereign with the grand. But again, the point is, in this also, even if we are going from the lower to the top of the hierarchy, then again, the question on the topmost of the hierarchy, norm at the topmost of that hierarchy, that is called the basic norm or the grand norm, that how that is valid. Now, this is the presupposition of the Kelsen's theory also, like the Austin supposes that sovereign will command the habitual obedience. Similarly, the Kelsen's understood that grand norm should have the it's valid, then only the other legal norms will derive their validity from the grand norm, and the entire legal system makes sense. Now if we just doubt the validity of the grand norm, the whole theory of the Hans Kelsen's collapses. It's all shut down. So that hierarchy will only exist if the topmost is presupposed as the valid grand norm, right? Then again his theory has few key concepts, that the purity, like he said that the law is something which is distinct, which is not like any other social sciences, because when we study law is something which is a part of society. At present we cannot say that law is something which is devoid of other social sciences, because when we discuss, we are making rules for the LGBT right, third gender, any other thing which is a developing criteria in our nation, it means we are again doing an interdisciplinary study. We cannot make a law without studying the society, because that is made for regulating the society. Then again, we are talking about the hierarchical. So that pyramid model of the Kelsen will only survive if we believe that the topmost is valid. Now, again, the question how that is valid is questionable in the Kelsen's theory. So grand norm concept is very dynamic, and he says that the revolution can change it. For example, majority of the people or the common consciousness of the people is of the will that no, the grand norm has to be changed or come up with the revolution. Then in that cases, even the new grand norm can take place. So for example, initially the popular consciousness was lying, there's his theory of Voltaire, obey the monarch. Now it is to obey the new constitution. So if a revolution succeeds in this manner, that will be a successful. Then again, you suppose grand norm to be valid, you supposes the grand norm to be giving authority to all other norms, then this again becomes very dynamic to understand. Now, what is the relevance of this classical theory of jurisprudence, or we can say this pure theory of law in today's modern society? That again, it gives value to the hierarchical structures. Wherever the hierarchy is followed, wherever this lease, regulation, codification, validity of the legal acts comes into picture, yes, the modern relevance can be there with respect to the Kelsen's theory. Now coming to the next is the H.L.A. Hart. Now H.L.A. Hart came after Hans Kelsen, and he talked about in his work the concept of law. So Hart was, we can say, is like soft positivist, not exactly so soft, because there are heartfuller debate also. If you go on, you can understand the hard and soft positivist approach. So Hart has built upon the critiques of Austin. Whatever critiques we have understood that Austin theory has failed or not reached that thing. So his theory became very influential in the 20th century. And for him, law is not merely commands. So he says that law is like a rule. Because in modern day also, if we talk about, when we say law, even the definition of the constitution includes law means so under Article 13. So it is not only legislation, it is also rules, regulations, bylaws, right? So he says that this system of rules which he's proposing is comprising of two rules. One is the primary and the other is the secondary rule. So he dismantles the command theory, means whatever the Austin has made as the command theory, that law is a command backed by the sanction, command of the sovereign backed by the sanction. So he pointed out that there's a problem of sovereignty, there's a problem of morality, customs, and power conferring rules. Again, the Kelsen, like how that Grundnorm will be valid, how that can be changed by the revolution. So he tried to go through that critiques and finally come up with the new system on that. So instead of a sovereign, he tried to focus on the rules, and rules he has further divided primary rules and secondary rules. So he says that primary rules are something which imposes a duty, and secondary rules are the rules about those rules. So the secondary rules try to remedy the defects of the primitive system. So primary rules, for example, we have a rule against theft in the criminal law. So society with only primary rules will again suffer uncertainty, status, and inefficiency. So he again has certain rules in the secondary rules, calling it, says that it is being the humans, or we should also have certain rules of secondary rules. For example, rules of recognition, rules of change, rules of adjudication. So rules of recognition is defined like a master rule that specifies the criteria for identifying valid law in that system. Example, whatever the Queen in the Parliament enact as law, this is Hart's answer to the Grundnorm. But he sees it as a social fact. And rules of change, for example, rules that govern how laws are made, amended, or repealed. Because if we say primary rules only, we have a rule and it is not changed with the changing times of the society, we cannot say that we are a progressive. We will just be a static society. And again, that system will be inefficient. Then again, that system will become ambiguous. There will be no clarity. There will again be uncertainty. Then we have further rules of adjudication, means the rules that empower the courts to judge violation of primary rules. Because we have a rule, again, that will go to the court. Court has to decide. How that court will decide means there are certain rules and regulations that we follow. For example, if there are traffic rules, even if we are taught, not taught, or we are like the traffic police is standing or not, what we see in the presence is different. But yes, we have this habitual obedience that yes, if there are traffic rules, we will follow. So for a Hart, a legal system exists where both kinds of rules are followed, the primary rules as well as the secondary rules. So in modern relevance, if we talk about, so his model is the dominant framework for understanding common law systems, right? Because when we say adversarial and inquisitorial system, then again, the approach towards the law deciding is different. So it explains why the precedent should hold a value, what legislative process, and the role of officials with unparalleled sophistication, right? So comparing till now what we have seen from the time of the Socrates, then we have Plato, Aristotle, then we have Hobbes, Locke, Rousseau giving the social contract theory, and then we have the positivism. So we have two proper schools and the theorists and the their classics that we wanted to cover. And based on that, we cannot say either natural is good or the positivism is bad. We again have to see that what is the middle path or what is the good path in that, how we can imbibe the good things of the natural law and the greatest things of the positivism and come up with the new rationale that suits the present need of the society. Because it's if we follow just natural law, we'll be lag behind. If we just follow positivism, again we'll be behind, because what is the present need of the time depends upon understanding the goods or the greatest of both the classics of the jurisprudence. So again, we have to see whether these things, whether these jurists, whether the classics given by these jurists, like the province of jurisprudence determined, or the Leviathan concept, is still applicable in our societies, which are like pluralistic societies nowadays. So you see, natural law, if we talk about, will again always gives us the indication that, for example, if we say murder, so murder will always be an offense. Even if you come up with the law that killing of somebody is not an offense, that is again very arbitrary. That will not be acceptable in the society. So morality, divine reasons do play a role while making any laws today also. But in legal positivism, we say the authority lies in that, yes, you have to enact it. Even if you know that murder is an offense, it is a bad practice, come up with the law on that. So that is how these origins differ. And For a natural law, any law that is human-made law, that should align to that. And for others like legal positivism, it is only valid if it is procedurally correct. Now, natural law focuses more on justice and ethics, whereas legal positivism more focus on codification, order, and certainty of the law. Thinkers, we have already discussed few of them. Because of the paucity of the time also, try to limit our discussion. Now, the relevance. For example, how this relevance, how this natural law is relevant today, how this positive school is relevant today. So one of the greatest example for the natural law influence is the human right discourse. We talk about many human rights. What is right to life? Is it being all first recognized in the law, or it was something that was existing from the time immemorial and emanating from the God's will? So again, that helps us to understand. Then when we talk about the administrative and the constitutional law, we have rule of law, we have separation of power, we have hierarchical structure. Then how the things are being governed, who will be empowering whom, who will give the authority to whom, how these legislations will derive their validity from the one another. Then that is again the positivist legacy that we are still carrying out. Now, if we come to the conclusion of our discussion today with the natural and the positivist, I say we cannot conclude, because this is a continuing conversation that will go on decades and decades, because we are comparing two systems, two classics, which are based on different foundation. And even if we now compare with the historical, sociological, and the realism school, we have again different foundation. These schools in their approach are different from the very inception. Hence, we cannot have some convergence to that. What we can understand is the best practices of both the system and come up with the what is suitable for our system, right? So it is not that one jurist which is coming with the Austin has came up with something. Even if Austin has criticized or the Bentham has criticized natural law, it is not that we presuppose or whatever Socrates or the Plato and Aristotle said is something bad. Because still we follow the Socratic method of teaching many institutions. How we say Socratic method? Because again, that is building on the foundation that we will, by our insights, we'll come up with something, and then we will see that whether it is right, we'll experiment on that. So this is how the things goes on. Now, when we talk about Austin, so he somehow secularizes and simplifies the law, separating from the morality as taught by St. Thomas Aquinas. Now, Austin, again, Kelsen refines the Austin's theory. He tried to have some logic with the hierarchy of the norms. Then again, Hart humanizes and complicates the model by introducing social practice and the internal point of view. That is the secondary rules. So no theory is, we can say, is right or wrong, but yes, how these classics are even governing us. For example, classic when we talk about, so even the Indian knowledge system when we talk about, so for example, the people always say, we always heard a debate, some people say, if like in every religion, I'll not be pinpointing, so every religion has good or bad practices. That is what we need to understand, that what is to be carried forward and what is to be not. So now this is for you, that I open up it to you, like all the participants. It is up to you that which side you want to choose or not to choose. You have to understand the vocabulary of each tradition, each classics, be it the concept of law, be it the province of jurisprudence defined, be it Leviathan, be it anything, be it like the Republic. When you argue a case, or you draft a legislation, or you critique a judgment, you will implicitly drawing on these frameworks. For example, whenever you're talking on any topic in the class, or even the students are discussing on that, or you are elaborating on any law topic, you always have these things in your mind. For example, are you appealing to a higher moral principle? Again, you have to go by the principle of the natural law. Again, the classics of the natural law will have an impact on that. Second, if you're focusing on the plain positive text of a statute, you're addressing the need that, yes, this is the law on the point, this is the written. Again, you're following the Austinian positivism. Now, that doesn't mean that you do not value the natural law, or the natural law has no implication, no authority on that. Then, for example, you are analyzing the validity of the any norm with a hierarchical system, then that is Kelsen, right? That is the Kelsen hierarchical system. The next, are you considering the social rules and practices that constitute a legal system? Again, you have heart in the mind. So what I try to conclude, that these classics are the tools and they help us to achieve our ends. Our challenge is how we use them wisely. Wisely in the sense because how natural law, if classics, if we just go by, know what is this the law that there should be emanating from the God, then we do not have a clear-cut answer. Because in present time, if somebody asks us, and we always say ना कि आस्था के में लॉजिक नहीं होता है, तो सिमिलरली नेचुरल लॉ अगर आप फॉलो कर रहे हैं तो आपसे कोई पूछे उसकी वैलिडिटी कैसे होगी, दिस इज द लॉ एमिनेटिंग फ्रॉम द गॉड, so will you ask the god to come and plead for that? There are many movies also, like I'm not remembering the name, where they have made a case against the god. So that looks okay, but being from the practical point of view, being in the legal fraternity, we what I think is that no classic is good or bad. It is only as a tool, and it provided as the foundation. Because now today, if we are discussing the realism school and we are talking about positivism, that this was written law, so somehow that realism is again the result of the critiques of these schools only that we are talking about. This is what I have tried to prepare for you all. I hope I made some sense to you, and thank you from my side.
It was dot on
Uh,
time, 9 o'clock. So great.
Oh my God.
Yes, Vikas, over to you.
yes, ma'am. There's a participant who has raised their hand, Miss Irmala.
Okay.
Hello, ma'am, and thanks, Dr.
Hello.
Gupta, for giving this opportunity. Ma'am, as far as natural law and positive law is concerned, I personally sense that when positive law doesn't have any answers, we look to a higher moral principle, and that can be named as natural law. For instance, post-World War II, they had Nuremberg's trial, and the exes were asked, why did you murder Jews? And the soldiers answered that we were following the orders of superior, because that was the black letter law that kill people of certain faith or religion. But the counter argument was that though it was an order of your superior, though it was a law, you should have followed higher principles. You cannot murder someone. So I feel that when positive law is unjust, we will learn higher
We
moral
have to
principles.
abandon. Yes,
That is
I
what I
totally
say.
agree with your, yeah, I totally agree with your observation. We cannot have a like one sophisticated approach. We should have a mixed approach, hybrid approach of taking the best of all.
And in contemporary times, madam, in Shreya
Right.
Singhal versus Union of India, they declared Section 66A of IT Act 2000 to be unconstitutional, violative of Article 19(1)A and not saved by Article 19(2). In that also, black and white letter of law was that police had arbitrary powers of arrest as far as 66A was concerned. But it was found to be unconstitutional. We relied on higher moral principles, that fundamental rights to freedom of speech and expression has to be protected even in the cyberspace. So again, here I feel that natural law principles prevail over positive law.
Exactly, I completely agree with you. Thank you, Ramal.
Yes, we have one more participant who has raised his hand, Mr. Sharad Junjanwala.
Yes, thank you for this opportunity. I think I have a question and observation as well. So I think this AI, what do you think, ma'am? Will it move us towards the natural direction or the positivist direction? Or what is your what are we seeing the trend actually?
So you are talking about AI. Do you have any particular aspect of that you want, or just a discussion with respect to that how AI is generating the content and everything? So whatever question I have understood as of now, again, when we talk about AI, AI is again based on certain model principles. There must be, like, I'm not from the computer science. I cannot know how that like coding and all is done. But I think again, we have given a preset for that. Based on that, only the information is being developed. So again, what I think is that AI is again mastered on something of coding is there. So some positivist approaches is still there. It might be that building on the same, it comes up with the new thing. So that will not be natural, not towards the natural perspective, but again, more like synthesized perspective, like we can go for realism. But I do not see the scope of that naturalism in that. This is my perspective. You may differ also.
Okay, I hope the question has been answered. There is a question from Ms. Ramaya SR. Ma'am, if I may add to that, what is the relevance of naturalism in giving legal personhood to AI?
The same question.
No,
What
she
you
has.
said, can you?
Yeah, the question is, what is the relevance of naturalism in giving legal personhood to AI?
I think still we are not so much clear with the laws and the regulation that regulate the AI in India. So again, I cannot say, but what I think is it is not the result of the natural law. It is the human reasons that have only developed it. And they have like doing the coding. AI is the result of the human instinct only. It is not something emanating or coming naturally. The results may be further developed based on that coding. And we don't know how that situation will be handled. Still, we are in this. Yeah, is not an okay. All right.
So, ma'am, as I can see, there are more than 50, 60 thank you messages for you in the chat.
Okay.
Adding,
That's a
adding,
great
just
thing for
adding,
me. I hope I made some value to the session.
ma'am, it was indeed a very wonderful session. So, officially adding towards it, moving towards it. Thank you so much, ma'am, for delivering such an insightful and thought-provoking session on classics of jurisprudence. Yep, the
Thank you so much,
presentation.
Vikas.
Yes, ma'am.
Actually, time was not
presentation.
permitting for that. Otherwise, if we have also discussed sociological, historical, and came up to the realism, that would have been a more wonderful session.
Ma'am, it was indeed a very wonderful session. Everything
hope
that was
so.
covered was perfectly on the point, well detailed and precise as well. So, ma'am,
Thank you.
the presentation that you gave was very clear, honestly, very nuanced understanding of the foundations of jurisprudential thought, from natural law to positivism and beyond. Also, the way you connected all the theories with contemporary relevance helped participants not only appreciate the historical depth of jurisprudence, but also to reflect on how these classical ideas can continue to influence modern legal systems. Also, ma'am, the clarity given was tremendously perfect, ma'am. So, on behalf of Law Teachers India and SNBP Law College, Pimpri, Pune, I extend our heartfelt gratitude for you to sharing your expertise and guiding us through such an important aspect of legal theory. I would also like to thank all our participants for their active involvement and our organizing and technical team for their continuous support and ensuring the success of this session. So with this, we conclude a second day of FDP on jurisprudence and legal theory. And we are looking forward for welcoming more speakers in the upcoming sessions. Thank you, everyone, and have a wonderful day ahead. Thank you, ma'am.
Thank you,
Thank you,
Vikas. Just
sir.
one thing. I think somebody asking for the PPT. So should I share with Dr. Kalpesh and that can be shared with
Yeah.
the people?
Yes, ma'am.
Yes,
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 ma'am.
yes.
If you're okay with that, you can share it with Kalpesh, sir. He'll forward it in the group.
Thank you to all the organizers. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you, ma'am.
Thank you.